A new set of criminal laws will come into effect in India on 1st of July. These are called the Bharatiya Nagarik Sanhita, Bharatiya Nagarik Suraksha Sanhita and Bharatiya Saksha Adhiniyam. These three laws seek to replace the British era penal codes called the Indian Penal Code, the Criminal Procedure Code and the Evidence Act. However, these laws have actually courted some amount of controversy. Experts have questioned the lack of transparency in their framing, and concerns have also been raised over addition of new provisions which experts say give extraordinary powers to the law enforcement agencies, and they also warn against the potential abuse of these provisions by police agencies. The Print brings you a three-part series in which we will decode each law individually. In this episode, we will talk about the Bharatiya Nagarik Suraksha Sanhita, which is the Criminal Procedure Code. And for that, we have Supreme Court Advocate Nipun Saxena, who has extensively studied all the three new codes. Thank you for joining us, Nipun. So let us, before we delve deeper into what is the cause for worry, can you explain what is the importance of a procedure code?
Right. Thanks, Bhadra, for having me. One of the most important attributes of any criminal justice administration system is its procedure. Now, the procedure regulates everything that goes inside a police station, that goes inside a criminal court, that goes inside the justice delivery system from a step-to-step basis. Say, for instance, from the point of commission of the offence till the point of registration of an FIR or a criminal complaint, investigation, inquiry, trial, sentencing, appeals, revisions, bails, everything is governed under the procedural scope. Right?
Okay.
And therefore, procedure assumes considerable importance.
Okay. So, if there is any violation of the procedure, can an arrest be challenged before the court of law?
Absolutely. Say, for instance, just to give you an example, if you are to arrest a woman after sunset, right, and you are not accompanied by women police officers, then absolutely that arrest becomes an illegal arrest.
Okay.
So procedural safeguards are put in place because they will subserve our fundamental right under Article 21.
Okay.
Right. Therefore, insofar as, and more so when it comes to criminal procedure.
Okay.
Because any violation of any of the procedural requirements will have a direct bearing of a fundamental right to life, personal liberty, and also procedure established by law.
Right, right. So it's extremely important for the citizens to be informed about these procedures because they directly touch upon our fundamental rights.
Absolutely.
Okay. Let's come to the Bharatiya Nagarik Suraksha Sanhita. Now, as I just said, there is a lot of concern around addition of new sections in this code. Can you briefly tell us what are these new sections?
Well, so now there has been a complete overhaul of the system as we know it. From the time of Macaulay, which was in 1894, there was a law which was in place which governed the British Dominion. In the year 1973, contrary to popular perception that the law is colonial, the law was amended.
We are talking about the criminal procedure
code,
which will now become an erstwhile.
Right. So, not too many people know, but there were as many as 6 law commissions, and they studied extensively these laws for 13 years.
Okay.
These laws were thereafter brought out after a holistic consultative process which spanned across 13 years. And it was thereafter that the Criminal Procedure Code of 1973 came into being.
So it would be not right to say that the CRPC was a colonial era.
Absolutely.
Code. Okay.
Absolutely. It is in fact.
So it's quite Indianized.
It was so Indianized. In fact, every single provision which said British Dominion, etc., was converted into Indian territories, Union territories. In fact, interestingly, even the state governments have the power to amend.
Okay.
And therefore, there were various state amendments which have now all gone for a toss.
Okay. How they have
because of the new laws that will come into place from 1st July 2024. Every single state amendment now will be in limbo in that sense of the term, because we don't know whether those state amendments will now apply to these new laws, or every state legislative assembly will have to now bring corresponding amendments to their own laws, which is the first legislative problem that I see. Now, in terms of inclusion, let's first list out the goods that have happened, and then let's talk about the bads, right? So one of the good things that the new criminal laws, in fact the procedural aspect that they try to focus on, is the inclusion of audio, video, digital evidence taking during investigation, during everything that a police has to do.
So why do you see it as a good inclusion?
Right. So first of all, I think it is very good because it walks step by step in terms of the future that India is going to enter into. We have new modes in which crime is being committed. There are new ways in which offences are being caused. We have problems which now are staring us in the face, such as deepfakes. We have problems with respect to evidence gathering. We have problems with respect to our reliance on technology as a means of sustenance. In order
so the nature of crime has changed, basically.
Absolutely, which is why it becomes all the more necessary that our rules of procedure and evidence can walk hand in hand with the changing dimensions of tech. Right. However, those are some of the portions that are very good. Another very important thing that which is good is the aspect of proclaimed offender. Hitherto, what used to happen was, if a person was pronounced or proclaimed as an offender, then the trial used to stop right there. Right now, what has happened is that the trial will go on, and the proclaimed offender will have to necessarily be brought back to the criminal justice delivery system for him to then agitate his grievances. So there are certain provisions which are found very interesting. I don't know whether they would be challenged at some point of time, but they say that a proclaimed offender does not even have a right of appeal unless and until he first surrenders. And thereafter, the trial will proceed in the manner it is to proceed, and there are certain procedural safeguards which I really liked. One of those was that if the court feels that a very important testimony has taken place in the absence of the proclaimed offender or his counsel, then he will be given the opportunity, subject to the discretion of the court, to again cross-examine that person. Right. So those are things which
some safeguards are there.
Some safeguards are there, which is very good. But now let's come to the not so good parts of it. And I am using a euphemism when I say that they are not so good, because they are outright, in my limited understanding, unconstitutional. The first of those is the aspect of preliminary inquiry. Right now, there was a Supreme Court decision in the year 2014, which was Lalita Kumari versus State of UP, which did away with an old and archaic practice specifically resorted to by many police stations. They used to register, before registering a case, they used to carry out a so-called preliminary inquiry, which was never even there in the in section 154 of CRPC, which is the old one. Now, it said that if there is a cognizable offence, if it discloses commission of a cognizable offence, you have to immediately register an FIR.
That's what the Lalita Kumari
judgment also says. It says if the police officer does not register an FIR, action will be taken against the police officer. So now that was a twin safeguard. The first safeguard was to the complainant. Gone are the days when police officers would ask for bribes or would operate under pressure. They will not register an FIR. They would make a person travel from pillar to post to register it. So if you don't, if the police officer does not register an FIR under 154, you have to go to SP under 154(3). If he does not act, you have to go to criminal court. Then you have to invoke writ jurisdiction. So all that hassle was decisively brought to an end because the Supreme Court pronounced its verdict in Lalita Kumari. Out comes preliminary inquiry provision, which now says that if an offence is committed, if the punishment for the offence is for a period ranging between 3 years to 7 years, it will be the discretion of the SHO to decide
So, which means that if there is any offence in which the jail term is between
3 years to 7 years, it will be the discretion of the police officer, the SHO, whether he will immediately register an FIR or whether he will cause a preliminary inquiry to be.
So, does it mean that the new provision has virtually done away with the requirement in the Lalita Kumari judgment, which said that the FIR should immediately be registered?
That's right, Bhadra, and that's the most concerning aspect of it. See, Lalita Kumari was very unequivocal when it said that the police officers are here to serve the people and therefore they have to register an FIR if it discloses the commission of a cognizable offence. There are no two ways about it. Now, what this does is, this particular provision now introduces a new subclause 3. It says that if the offence is punishable with an imprisonment term between 3 to 7 years, then it is the discretion of the SHO who would either register the FIR or would conduct a preliminary inquiry. Now, the difficulty is that you confer too much discretion on the SHO.
Right.
And this would be an unfortunate pre-Lalita Kumari era that we would be transposed to.
Right, right.
It would in fact reinstate the system of taking bribes, taking money to either register, or if the person or if the police officer has contacted the accused already, then he would not register the FIR. He is sort of given a certain amount or under political pressure.
Is there a deadline in the law to conclude this preliminary inquiry?
That's right.
Or is it like open?
No, there is a deadline. He has to take that decision within a period of 14 days.
And what if he decides not to register an FIR?
Then you go back. If he decides not to register an FIR, then you have to file an application before the superintendent of police. If the superintendent of police does not act on your application, then you have to again go to criminal court under section 200 or file a writ petition under 226 or file a 482 inherent proceeding. So this, in my understanding, has further complicated it, and that's not just all. The most problematic expression used is prima facie satisfaction of the police.
Oh, and that is very subjective.
That's right. And second thing is, this prima facie satisfaction is to be arrived at by courts, not a police officer.
Yeah,
investigative wings and a judicial wing are two completely separate organs of the state. One cannot entrench upon the other to carry out a task which is the exclusive domain of the judiciary. Now, if a police officer or an SHO in his own understanding comes to the conclusion that no preliminary inquiry is warranted or no FIR is to be registered, then the problem compounds, because there are close to 98 offences under the new Bharatiya Nagarik Suraksha Sanhita, which will now have a direct bearing on this provision, because now in all of these 98 offences, the police officer alone can decide whether he wants to register an FIR or not.
So this means these 98 offences, in them the jail term is between 3 to 7 years.
So that would include theft, that would include cheating, but that would also include various offences, grievous hurt, acid attacks, sedition, the newly drafted version of sedition. All those provisions will fall squarely and will be hanging on the discretion of the SHO.
So how does this play out for the complainant and the accused in practical terms?
Well, for the complainant, it's disastrous, because now in what was a matter of his or her right to get an FIR is now left to the discretion of the SHO. So how, you see, you call it Bharatiya Nagarik Suraksha. Where is the Suraksha of the Nagrik, I ask? And now it also complicates the life of the accused even further. Say for instance, today if you register an FIR, then an accused is entitled to a notice under section 41A of the CRPC. No immediate arrest to be made in terms of Anish Kumar judgment. But now, at the stage of preliminary inquiry, the accused will be called up, he would be harassed.
Can be summoned any time.
Can be summoned at any point of time, and you need not even resort to the requirements of 41A notice now.
And would the accused be told why he or she is being summoned to the police station?
Not at all. He may have absolutely no idea, and that's exactly the same problem that we have in PMLA. If an accused is today being summoned, he does not even know whether he is being summoned in the capacity of an accused or as a witness or as somebody who has just heard of it, or somebody who is an approver, you don't know today. And that is, which is why it is pushing the law,
Right.
or pushing the entire criminal justice system on a regressive path.
Right.
It is, these inclusions are not progressive.
Right. Nipun, I think another area of concern is with regard to the police custody. So, till now, the police could get custody of an accused in the first 15 days of the arrest. But I believe certain changes have been incorporated in the BNSS to now make it very flexible. Now, the police can seek custody of the accused within either the 60 days or within 90 days of the arrest. So, can you just explain a little bit on this as well?
So now there is a specific provision under section 187 of the new BNSS. Let me first, it is slightly complicated, so I'll first take you through what was there in the old regime and now what are the changes that have been brought in the new regime. Under the old regime, if a person was arrested, that person could be taken into police custody for a maximum duration of 15 days. Now, if the offence is one which for which the maximum imprisonment term is 7 years, then the police is to complete the investigation by filing a charge sheet or a closure report, whatever it is, within a period of 60 days. But if the offence is a far graver offence or heinous offence, say murder, rape or any of those offences, then the police gets 90 days to complete its investigation. Now, if a person is in custody and the police fails to file its charge sheet within the set period of 90 days, then the person is entitled to what you call a default bail.
Right.
Also, if the arrest or if the police custody goes even 1 day beyond the 15-day period, the person can be immediately released on bail.
Okay.
Because that arrest becomes illegal arrest.
Okay.
Right? Because under the law, the second proviso to section 167 of CRPC categorically capped the total number of days where a person could be kept in police custody.
Yeah.
Now, this particular cap has been omitted under the new law. Under the new law, so if anybody is to read it, it would mean that earlier statutory limitation of 15-day period maximum custody has now been done away with. So, a police custody can well go up to 60 days or well up to 90 days.
And at any time during this period?
At any time during this period. It does not have to limit itself at 15 days.
To the first 15 days?
Only. It could go from day number 14 to the 89th day also.
So, how does it impact a citizen's ability to get bail? Because normally what happens is courts prefer, in the sense when a person goes into judicial custody, courts tend to take a lenient view, unless it's a very heinous offence. Courts tend to take a lenient view and give bail depending upon whatever preliminary evidence that is placed before it. But what happens to the chances of an accused getting bail in this circumstance?
Now, Bhadra, this is very complicated in that sense. Usually, people talk about bail. People don't talk about remand. Most of the arguments happen for remand because we all know that there have been police excesses during police remand.
The police remand,
and not under judicial remand.
Right.
So, when a person is in judicial remand, then there is not that great or imminent a danger to the person's life immediately, because then that person is under the protection and supervision of jail authorities. But if the same person is under police custody, then the problem, then there is a greater level of vigilance which is required. Now, if the police custody exceeds 15 days, then all bets are off, because we all know what happens inside police lockups. Right? And if you are to sort of limit a person's fate to 15 days, the court should be far more vigilant. But if the person's spirit is broken for a period of 60 days or 90-day incarceration in police custody and not judicial custody,
right,
then all these procedural safeguards are sort of, their fate is preordained. It's very unfortunate then, right? So it has a direct bearing on Article 21 and Article 22 of the Constitution, which is no illegal detention beyond a specific period of time.
Right.
And Anupam Kulkarni and many judgments of the Supreme Court have said 15 days and not 1 day beyond that. In fact, I would go to the extent of saying that this particular inclusion is far graver than special legislations like NDPS and even Unlawful Activities Prevention Act.
Right.
In NDPS, you have the police is supposed to file its charge sheet within a period of 180 days.
Yes.
But still, the period of 15 days of police custody is very sacrosanct. They cannot exceed it. And with UAPA, while the police custody can go for a period of 30 days, but at the end of the 30th day, the police officer will be summoned by the court. He has to file a personal affidavit. Why further? To explain why further custody is required. You can't just put somebody in a police lockup for till kingdom come.
So which means the chances of what you just said, default bail, will become obviously more tougher.
Absolutely, because now what the police officers would do is that they will resort to the previous practice of filing supplementary challans after supplementary charge sheets,
and
therefore keep a person in jail
endlessly.
So that's
another area of concern raised by the critiques is that this code brings back handcuffing of under trials. Can you just share your thoughts on that?
right. So in the year 1970s, we had two very important decisions. One was the D.K. Basu and second was the Sunil Batra versus, and of course from 80s till the 1997, those were two of the foremost authorities which laid down certain basic principles. They said that a person who is incarcerated is also a human being. He or she also has a right to dignity, right? And they also enjoy the presumption of innocent until proven guilty. Therefore, it is only in exceptional cases that an under trial will be handcuffed. Let's say if that person is a habitual offender and there has to be a police
or a hardened criminal,
right? A history sheeter, if you want to call that, right? It is only then and then that a person would be handcuffed. Otherwise, a person will not be handcuffed. Generally.
And that is because even if you're an under trial, you have the dignity which you are entitled to under the Constitution.
Right. And I think that was the law which was settled long back in 1980s by Justice V.R. Krishna Iyer's judgment, right? Now what has happened is, we have gone back to pre-1980 days with this specific inclusion in section 43. It says that a person who is an habitual or repeat offender. Now the problem with this particular provision is, if a person is a habitual offender or a repeat offender or is sort of accused of an offence of say murder, rape or and so on and so forth, there is a specific category of offences that they have laid down, then a person shall be handcuffed.
Okay.
The problem is that a person is still innocent until proven guilty. This is what all the judgments have said. This is why any student of law who has ever touched Constitution or Criminal Procedure Code in their lives would tell you the first principle of law being that you can't just indiscriminately handcuff somebody. Now the problem here is that habitual offender is a judicially defined term.
Okay.
Repeat offender is not.
Okay.
Now say for instance, imagine, let's take a very basic dispute, a matrimonial litigation. A wife files a 498A complaint, a domestic violence complaint, a Stridhan returning complaint, 406 criminal breach of trust, right? So now there are 3 or 4 FIRs against a particular person. Now does that person become a repeat offender? It would mean that even aged people who are those mother-in-laws and father-in-laws of the world will now be dragged in handcuffs. It could be.
So it's quite ambiguous.
It is. In fact, if you leave these expressions unanswered, they are so susceptible. I mean, in fact, there are specific protections which have been laid down. There were guidelines under which it was only in very rare and exceptional circumstances that a person was to be cuffed. To cuff a person and parade that person to the court, which seems to be very problematic and against any notion of a dignified civilized society, is something that we are being brought back to that world, which we had abandoned and for good reason,
Right.
as long back as in 1980s.
So basically, takes you back, to the mercy of the enforcement agencies.
That's right. So again, Bhadra, therefore I asked the question, where's that Suraksha?
Right.
It's, I mean, I would have understood, and by no stretch of imagination am I saying that convicted people whose appeals are pending must be also handcuffed. But these are under trials. They are not even convicted.
Right. Let's talk about the implementation part, in the sense that once this code comes into effect on 1st of July, would it be implemented retrospectively or prospectively? And what happens to cases where the incidents have happened, say in June? So suppose the law gets implemented on 1st of July, but an incident has happened on the 28th or 29th of June, right? So how would this code come into play? Will the new code be applicable to that particular FIR, or would the procedure in the CRPC will be followed in that FIR?
There are two parts to it. First is substantive. Substantively, what are you charged with? What is the offense against you? Now, if the person who has been charged of an offense in June continues to remain an offense in July, then an FIR can be registered even in July under the new law,
which is the Bharatiya
Yes,
Sanhita.
Sanhita.
Yeah.
However, the date of offense is material,
Okay.
not the date of registration, for the purposes of the substantive offense.
Right.
But for the purpose of procedural procedural requirements of the law, the FIR can well be registered under the new act.
Okay.
But it will have to relate back to that offense, which may now be numbered differently.
Right.
But that's going to create a lot of problem, because here you have
So which means, so suppose even if an FIR is, say, registered under the erstwhile Indian Penal Code, but the procedure which the police will have to follow would be under the new
That's right.
Procedure
From
code.
on and from 1st July 2024, every FIR registered, or worse, every preliminary inquiry conducted before FIR is to be registered, will be governed under the new code.
Okay.
Even if it relates back to an offense which was committed at a prior occasion.
Okay. Okay.
Now
Now what is the problem?
Yes, the problem is that you have a distinction between substantive laws and procedural laws. Now, Supreme Court has said in multiple decisions that procedural laws can also have retrospective application. Now, if those retrospective applicability is to be seen, then it will lead to a lot of challenges, because you have changed quite a few things.
Right.
Right. And that, to my mind, is going to cause a great problem. Let me give you one instance. Under the Criminal Procedure Code, which is the old regime, you had a police case and you had a complaint case. A police case was an FIR which materialized into a charge sheet under 172. Under the complaint case, you had a section 200 proceeding, and cognizance was taken under 190, and thereafter summons were issued under 205. It was uniformly held that at any of these stages, which is to summon an accused, you don't have to hear the accused.
Okay.
The accused has no right to be heard at that stage.
Okay.
But now with the amendment, while insofar as police cases are concerned, which is an FIR is registered, the accused still cannot be heard.
Right.
But in complaint cases, there is now a mandatory requirement that that you have to give accused a hearing even before you take cognizance.
Okay.
Now that's really problematic, because there were three avenues. You could either register an FIR, or you could go to the criminal court and file a private complaint.
Yeah.
But now, at one stage, the accused gets a right of being heard even before he's summoned, whereas in the other stage, he has no right of hearing.
So from what I can gather after hearing you is that it now will become tougher for the complainants to get an FIR registered under this
That's right.
scheme.
It would be, because now any person who is a complainant who
Because
wants
the
to
level
file
of scrutiny has been
has increased. Now the accused will try to put all the obstacles that he or she could possibly can, which otherwise were to be sort of examined at the stage of discharge, or let's say at the stage of filing a quashing petition. Right? Now, all those elements of scrutiny will come back here. And this is going to result in a phenomenal increase in litigation. It is not going to cut down litigation. It is only going to increase, because at least for the next 30-40 years, you will have FIRs which are being, the trials, inquiries, appeals, revisions which are under the old regime, and new regime where new offences are being registered and are subject matter of a different regime. So a lot of interesting arguments
and the new regime virtually allows a challenge to every administrative decision taken in the court of law, right?
That's
at
right.
every stage.
At every stage. So you see, it's going to be very interesting, but I feel that some of these provisions which ex facie are very unconstitutional, the state legislations or the state governments may want to amend those.
Right. Well, my last question to you, Nipun, is about the impetus in this new code, which is, the tech-based approach in police investigation. But do you think that the infrastructurally, our police machinery is ready to accept this kind of challenge?
We are wholly unprepared. In an era where many police manuals still retain provisions for giving fodder to horses, which were abandoned colonially, right? We are looking at investigations, inquiries, where a lot of stress is being or focus is being given to technological evidence gathering, as if it were, without even looking at the logistical requirement, which is completely lacking. We don't have, and this is our experience in so many trials, that we are waiting for a forensic science lab report for 3 years. And none of those timelines of concluding trial within a specific period, or you see 6 months. For instance, let me just give you an example. They say, there's an amendment, a specific provision which says that all cases of sexual assault and rape cases and POCSO cases, the police must file a charge sheet within 60 days. Now, if you file a charge sheet within 60 days, how will you gather that forensic science examination report in time? You cannot. Within a period of 60 days, you don't have that infrastructure today. Maybe you may have it at some point of time in distant future, but until that time, all these commitments, which are these so-called deadlines, will never be adhered to. It is, you see, this is one of the biggest problems with these laws. The last time a law of such wide ramification was passed was after 13 years. Of consultative,
a lot of deliberation
went on every single provision. And
also to see how prepared are we.
That's right. And it was done in a phased manner. Right now, I have my doubts on how exactly it is going to be implemented. These chemical science or ballistic reports, or you see, or even bone ossification tests, they take years, if not months, to arrive. With the current system that we have, we are very incapable of meeting the deadlines. These are promises and ambitions that we cannot fulfill. There's also another very big problem, which is with respect to the evidentiary value of it. Earlier, the law was that under 65B of the Evidence Act, you have to just produce a certificate. Right? And if you are producing that certificate, then you don't have to produce the device. Say if you were to seize a computer, all that you have to do is give that certificate. Now you introduce terms like hash values, etc., which an ordinary constable who is carrying out an investigation will have absolutely no idea of. Hash value is something of a particular device, is something that even lawyers struggle with, judicial officers would struggle. It would require a very in-depth training at various levels, which has to be carried out, which unfortunately is not.
We are not ready for it.
We are not ready for these laws yet, which is why you would have seen that from many quarters, and for good reason, they have said, please delay the implementation of these laws.
That's right. Well, thank you so much, Nipun, for joining us today and talking about the good points as well as the bad points of the new Criminal Procedure Code, or the Bharatiya Nagarik Suraksha Sanhita. How it plays out, only time will be able to tell. as it is said, laws are meant for the good, but how they get implemented is to be seen. Thank you so much.